Does the type of Medicaid program affect estate recovery? Have you ever wondered how the type of Medicaid program you choose can impact what happens to your estate after you pass away? This is an important question, especially for those planning for long-term care. Let's break it down. Yes, the type of Medicaid program can indeed affect estate recovery. Medicaid Estate Recovery focuses on recouping costs related to long-term care services. Federal law requires states to recover Medicaid expenditures for long-term care from the estates of deceased beneficiaries who are 55 years or older or those who are permanently institutionalized. Long-term care services include nursing home care, home and community-based services, and related hospital and prescription drug costs. So, estate recovery is closely tied to Medicaid programs that cover these long-term care services. On the other hand, Medicaid programs that only cover acute care or non-long-term care services typically do not trigger estate recovery. However, some states may expand their estate recovery efforts beyond federally mandated long-term care costs to include other Medicaid expenses. This means that the scope of estate recovery can vary by state and the specific Medicaid program involved. When it comes to what assets are targeted for recovery, the Medicaid Estate Recovery Program usually focuses on assets in the deceased beneficiary's name. This includes the home, cash, bank accounts, vehicles, and other valuables. The home is often a primary asset recovered because it is usually exempt from Medicaid asset limits while the beneficiary is alive but can be subject to recovery after death. States also differ in how they define the estate for recovery purposes. Some limit recovery to probate assets, while others include non-probate assets such as jointly owned property, assets in living trusts, or payable on death accounts. There are certain protections in place as well. For example, a surviving spouse, minor children, disabled children, or siblings who meet specific residency requirements may be exempt from estate recovery. It is also important to note that Medicaid programs that do not include long-term care coverage generally do not trigger estate recovery, but this can depend on the specific rules of each state. From an elder law and estate planning perspective, understanding which Medicaid program a client is enrolled in is essential. This knowledge influences the potential for estate recovery and can guide planning strategies to protect assets. For instance, transferring a home before applying for Medicaid long-term care benefits or establishing certain trusts may help preserve assets. However, these actions requiring careful legal guidance to ensure compliance with Medicaid rules and timing requirements. In summary, the type of Medicaid program can significantly affect estate recovery, especially regarding long-term care services. The specifics of recovery depend on state law and the type of Medicaid coverage received. Therefore, it is vital for individuals to evaluate their Medicaid program when considering estate planning and Medicaid eligibility.